A proposal to legalize same-sex marriage falls short again in Springfield, largely because of concerns over its impact on churches and other religious institutions.
Supporters vow to try again in the new General Assembly that will be sworn in this Wednesday. Key players on both sides are here this morning in our studio. One big reason the gay marriage proposal stalled out in the state Senate after supporters had claimed to have the votes to push it through was summarized at a hearing by Springfield's Catholic Bishop Thomas Peprocki.
This radical departure from traditional belief and practices should not be used to compromise or erase the freedom of religion.
Lawyers Peter Breen of the Thomas More Society agrees with Bishop Peprocki. Attorney Camilla Taylor of Lambda Legal strongly, though, disagrees.
At that same hearing where the bishop spoke, Ms. Taylor was brought forth by those in favor of gay marriage to respond directly to the concerns of religious groups that parish halls, for example, might be forced to host a wedding reception for a gay couple. So, Ms. Taylor, let's turn to you. That is a real possibility if the church rents out its halls for other activities, such as the Boy Scouts or community events?
Well, if the church operates a piece of property as a commercial business and uses it in order to make some sort of rental income, then yes, the church is already covered by non-discrimination law that currently exists, and nothing in the marriage bill would change that law. That law exists unchanged after passage of the marriage bill, which means that the obligations that a church might have if it operates as a commercial business remain just the same with respect to couples and civil unions as it would if a couple wants to have a marriage celebration.
What do
in
you
that
say
space.
to parishioners who say, so what, big deal, let's just get this thing passed downstate?
Well, there are already protections for religious organizations that wish to maintain sacred sanctuary space. No religious organization or faith denomination or minister, for that matter, will ever be forced to perform a ceremony that it chooses not to perform, that is contrary to its religious dictates. That is already settled law, and that also continues to exist. So if
they can even do that with heterosexuals as well, to decline to perform a ceremony.
Absolutely correct.
Okay.
Absolutely correct. For couples who come from different faith backgrounds, or maybe they're previously divorced and they haven't had an annulment, already faiths get to make their own determinations about who is eligible to marry. So if a parish hall is intended to be maintained as sacred space and is something that is not operated as a business, then the church has absolutely nothing to worry about, and no one can ever possibly force them to open it up to perform ceremonies.
But churches are worried, Mr. Breen.
Absolutely, and Ms. Taylor is incorrect that they have to rent out their halls right now. There are current protections in law, particularly in the Civil Union Act from 2010, that allow religious institutions some level of protection. It's not a strong protection, but it's enough to do that. For instance, it protects Catholic charities when it provides private adoption services. Of course, the governor and the attorney general had stripped public adoption and foster care services away from the Catholic charities. But there are protections in law currently. Those protections would be stripped out with the current version of the bill, the same-sex union.
Ms. Taylor says, though, that the concern that was raised at this hearing last week in Springfield, that the parish hall might have to host a gay wedding reception, is already in the law.
That's false. That's absolutely false. In fact, it's not just the reception. You could come in and have a gay wedding at the parish hall. I mean, there's nothing that stops you. I know folks.
Well, her argument, though, that that's already required by law if you rent it out for other purposes.
Right. She's incorrect on that. We have protections in the civil union law on that front. And I mean, if she is correct, then where are the legal actions being taken against parishes? You would have heard about them, and we would have already been talking about them at another session of this show.
Well, already, I mean, our organization drafted the civil union law. We also contributed to the drafting of the marriage law, and there are absolutely the same protections in both pieces of legislation. And interestingly, the Catholic Church opposed the civil union law, and it is opposing the marriage bill, and they made the same arguments with respect to the civil union law that you are hearing today. The truth is that religious institutions that maintain sacred space just for worship services are absolutely protected. They're protected not just by this legislation, but by the Establishment Amendment clause.
And the First Amendment.
That's right.
But the fight's not over the sanctuary. The fight's over these parish halls and gymnasiums. The idea that if you rent it out to the Boy Scouts for a meeting, you'd have to rent it out for other activities. I mean, Mr. Breen has a point, though, given how litigious our society is and the number of unemployed lawyers out there. Why haven't there been lawsuits already suing Catholic parishes for that?
Well, I think because based on the same language in the civil union law, which exists in the marriage law, there is absolutely no conflict here between the need for complete protection from discrimination in public accommodations and the need of religions to be able to determine for themselves, free of any governmental interference, who is eligible to marry within the dictates of a particular
Camilla,
faith.
I'm going to cut you off right here. Peter will give you a chance to respond after the commercial break.
Let me ask Peter Breen of the Thomas More Society. You've been opposing this for years, but the politics seems to be moving against you. Even the Illinois Republican Party chairman in favor of it now. And the Christine Radogno, the Senate Republican leader, saying that if Ms. Taylor and her allies made some changes in the language, she'd vote for it.
Well, and those are interesting statements. At the same time, the changes that would need to be made would be so drastic, I'm assuming that Ms. Taylor and her allies would not agree to them.
It goes to this public accommodations thing, Ms. Taylor. Would you do that to get Republican votes? Would you change that?
Well, certainly the price for the freedom to marry should never be allowing discrimination against lesbian and gay Illinoisans or any other Illinoisans. I mean, we've always understood as a society that it's important not to discriminate in restaurants, in hotels, in all sorts of public spaces on the basis of race, sex, and sexual orientation. So that's an important principle that we will stick to.
Let's look ahead to what's going to happen next week. In a letter last week, Cardinal Francis George said the state has no power to create something that nature itself tells us is impossible.
And that's actually being read in the parishes today.
Exactly. And where do you see this going next week? What has to happen next week?
Well, this is a question of when it's going to happen and not if. So it could happen in just a few weeks in the legislature. It may take a little bit longer than that. And of course, we have a court case that we fully expect to win ultimately in the Illinois Supreme Court. So we're very confident that we will be the 10th state in the country to allow same-sex couples to marry.
For those who don't know all the ins and outs, that case is in front of Cook County Circuit Court Judge Sophia Hall, and you're on the other side of that.
Right.
You two are actually on both sides in this thing. So what's going to happen in that case if the General Assembly doesn't do it? Because that's a way in which gay marriage might be legalized by court ruling.
It could, but really you're going to see the U.S. Supreme Court come down with its decision on the Prop 8 case and the related cases.
Out of California.
Correct. And there are other cases that are really ahead of ours in the federal system. So the United States Supreme Court will make its ruling. That will probably control the issues here in Illinois.
Right,
Peter, and where do you say... I was going to say, go ahead.
Should we give each of them 30 seconds to wrap up? Mr. Breen, why don't you give us yours, and then Ms. Taylor will let you wrap up.
Sure, thank you. The way we look at this, the point of this legislation is not to add an additional single substantive legal right for same-sex couples. But what it does is it brands as discriminators and bigots everyone in Illinois who believes that marriage is between a man and a woman. And you heard Ms. Taylor's comments earlier. It's discrimination. It's bigotry. So from that standpoint, that's what this bill is looking to do. And so we see it also stripping away at fundamental religious liberty rights from the civil union bill. But again, that main point is it turns our state's policy such that folks like myself, my wife,
Mr. Breen, you're wrapped up on your 30 seconds.
Right.
Ms. Taylor, your turn.
Turn us into discriminators.
Well, what this bill is really about is protection for the thousands of lesbian and gay couples around the state of Illinois and for their children who are currently labeled as being part of less worthy families. They are caused to have discrimination against them in schools by the school administrators against their children. In healthcare settings, we heard from a couple who actually was barred from seeing their child in a pediatric intensive care unit because they couldn't describe themselves as part of a married family, and the administrator didn't understand who they were or what a civil union meant. So it is extremely important that we end this government label that these families are less worthy of dignity than other families.
Camilla Taylor, Peter Breen, thank you both very much for joining us.